the Legal Collocations Toolkit. Today we're going to train one of the fastest upgrades in legal English, collocations. A collocation is simply a word partnership that professionals use automatically. In legal English, collocations are not nice to have. They are part of the professional code. If you use the wrong partnership, people will still understand you, but you will sound less precise and less credible. In this lesson, we will master a small set of high-value legal collocations used in court procedure, money disputes, and contract disputes. I will teach you what each phrase means, when to use it, and what to avoid. Let's start with the life cycle of a legal claim. When you formally start a court claim, the professional collocation is issue a claim, not do a claim, not open a claim. File a claim exists, but issue a claim is the sharper phrasing in this procedural context. Here is a clean example. After repeated non-payment, the claimant decided to issue a claim for $9,200. Once you decide to issue a claim, you usually work with a claim form. There are two actions you must not mix up: fill out a claim form and submit a claim form. Fill out means you complete the data fields, such as names, addresses, dates, and amounts. Submit means you formally send the completed form to the court. So the correct sequence is simple. You fill out the claim form. Then you submit the claim form. Next, once the court receives the form, it is processed. Processed means the court handles it internally through administration and system steps. Once processed, the claim receives a reference number. In real practice, you use that reference number in later correspondence. After the claim is processed, the next step is formal notification. The professional phrase is served on the defendant. You can also say served upon the defendant, which is more formal. Notice the preposition. It is served on or served upon, not served to. So you say, after that the claim was served on the defendant. Then later the case will be heard in court. Heard in court means the evidence and arguments are formally considered by a judge. Now let's handle two collocations that advanced learners often confuse: adjourn and suspend. Adjourn is used when a case, trial, or hearing is postponed to a specific later time or date. For example, the judge adjourned the trial until 10 a.m. on March 12th. Suspend proceedings is different. Suspend proceedings means the court temporarily halts the process, often without an immediate reschedule date. For example, the court suspended proceedings pending medical evidence. Here is the simple test. Adjourn equals scheduled delay. Suspend equals pause or halt. That distinction makes your writing more accurate and more professional. Now let's shift to financial language, where legal English must be exact. First, outstanding sum. Outstanding sum means the unpaid amount that remains owed. For example, the outstanding sum is $8,900. A close and useful adjacent collocation is outstanding debt. Outstanding debt is broader and describes unpaid debt that remains, especially where debt has accumulated. For example, the defendant has outstanding debt of $24,000. You will also see related phrases in professional writing. They include the amount outstanding and the sum owed. Next, due date. The due date is the legal deadline for payment. Interest often runs from the due date. So the due date is central to calculating liability. Now, incur fees or incur costs. This is the professional verb. If you instruct counsel, you may incur legal fees. Incur means you become responsible for paying fees as they arise. Here are 2 warnings. First, make fees is incorrect. Second, rack up costs is too informal for legal correspondence. Use incur. Now, run up a debt. Run up a debt means to accumulate debt quickly or irresponsibly. For example, he ran up a debt of $200,000 on company credit lines. Now, levy a tax. To levy a tax means to formally impose or collect a tax. For example, the government may levy a tax on imported goods. Now, 2 professional collocations for advice and caution. The standard phrase is take advice. For example, before signing, you should take advice. The formal equivalent of keep in mind is bear in mind. For example, bear in mind that in small claims, legal fees are often unrecoverable. Now let's move into contract language, where we have 3 core actions. First, performance. If a party does what they are required to do, we say they carry out an obligation. Obligation is a weak collocation set, so you can also say fulfill an obligation or perform an obligation. Here is a clean example in U.S. legal style. The contractor failed to carry out its obligation to deliver by April 1st. You could also say, the contractor failed to fulfill its obligation. Or, the contractor failed to perform its obligation. Quick accuracy note for American legal writing. If contractor is singular, use its, not their. If the subject is plural, contractors, then use their. Second, the break. In everyday English, people say, break a contract. The standard professional phrase is breach a contract. For example, by missing the deadline, the supplier breached the contract. A closely related form you will see constantly is in breach of contract. For example, the supplier is in breach of contract. Third, the duty. A claimant may have a duty to mitigate a loss. Mitigate a loss is a strong collocation that judges expect. It means taking reasonable steps to keep losses as small as possible. If a claimant fails to mitigate, the court may reduce the damages awarded. Bringing it all together. Now I will bring this together with a short model paragraph. After repeated non-payment, the claimant decided to issue a claim for $9,200. She filled out the claim form and submitted it to the court. Once processed, the claim was served on the defendant. The judge later adjourned the hearing until March 12th. The court could also suspend proceedings pending evidence. The outstanding sum remains unpaid from the due date. The defendant's outstanding debt continues to increase. The defendant breached the contract. The claimant will show it took steps to mitigate the loss. Now let's finish with a fast oral drill. Choose A or B and say your answer out loud. You will hear the answer after 3 seconds. You can pause if you need more time to think. Question 1. Do we say A, issue a claim, or B, make a claim? Answer A, issue a claim. Question 2. Do we say A, fill out the claim form, or B, write the claim form? Answer A, fill out the claim form. Question 3. Do we say A, served on the defendant, or B, served to the defendant? Answer: A. Served on the defendant. Question 4. Do we say A. Pause the trial until Friday, or B. Adjourn the trial until Friday? Answer: B. Adjourn the trial. Question 5. Do we say A. Mitigate the loss, or B. Lower the loss? Answer: A. Mitigate the loss. That's your core set. Use these collocations in your emails and documents, and you will sound clearer, more credible, and more professional. Thank you for listening.